Well, good morning, everyone, and welcome to episode 1 of the McCarthy Institute Presents. Today, we are joining Orrick for a discussion on the Romag case. In just a minute, I'm going to introduce our moderator, and he'll take it from there and introduce our panelists today. But first, I just want to encourage everyone in the chat feature in Zoom, if you would just give us a quick shout out, let us know where you're joining us from around the country. We have over 100 people registered for our webinar today, so we're excited to have you join us from wherever you are. And also, as we're moving through our discussion with our panelists today, if you would please use the Q&A feature to ask your questions, and be sure if you see a similar question to one that you are considering asking, go ahead and upvote that, and when we move to our Q&A session at the end of our panel discussion, the panelists will see those upvoted questions. So at this point, I'd like to introduce the McCarthy Institute Director, David Franklyn, and David is going to take it away and introduce our panelists this morning.
Hello, good morning, everybody. Our panelists for today are Mark Puzella and Sheryl Garko from the Orrick law firm, practicing worldwide but headquartered in Boston. They both are trademark litigators with many years of experience, and our topic for today is the Romag case in the United States Supreme Court, which came down just about 5 weeks ago. And Sheryl and Mark are going to present the case to us, and we're going to go through it and talk about what it means and maybe doesn't mean for trademark owners, for people in trademark litigation, for clearance, and for all related topics. So I would ask at this time if Sheryl and Mark, you could just say a few words about yourself by way of introduction, and then we can launch into the substance. Sheryl, if you go first.
Hi, I'm Sheryl Garko. I am a partner in the Boston office of Orrick, which just recently opened about a little over a year ago. I've spent my career basically litigating trademark, copyright, trade secret matters. All of the non-patent stuff is what I've focused on recently. I've had the privilege of practicing with Mark for many of those years, and we've litigated many interesting cases, particularly related to these damages issues that we're going to be discussing today.
Thank you, Sheryl. Mark?
I'm essentially the same. Sheryl and I have been practicing together for a very long time. I'm a trial lawyer. I focus on trademark and copyright litigation, mostly with a substantial practice that is in adjacent areas, false advertising, defamation, things of that nature. But we're essentially trial lawyers who do this sort of stuff day to day in the dispute context. But as a consequence of our disputes practice, we have a significant amount of experience in the advisory context, basically doing risk assessment and litigation avoidance counseling. And that's where this sort of thing comes in.
Thank you. Sheryl, would you start us off by giving a little bit of the context and the background for the Romag case? What, the role that damages play or have traditionally played in trademark litigation. And then Mark, if you would after that, take us through the case.
So I think we're actually going to do the reverse, David. I think Mark's going to start with the background, and then I'm going to pick up the case. So Mark, why don't you start with the background on damages and willfulness?
This wouldn't be fun if it went smoothly.
Yeah.
So as David suggested, I'll give a little bit of a primer on trademark damages. Trademark, the liability determination is based on the well-known likelihood of confusion analysis. And, once you have a finding of confusion, you move on to damages, and 1117 gives us the different modes of damages that are available. The plaintiff can get, and this is conjunctive, not disjunctive, which is important. The plaintiff can get its own damages, so it's actual damages, any harm that it has suffered as a consequence of the infringement. But a plaintiff is also allowed to get the defendant's profits by way of a disgorgement ruling. Oftentimes it's referred to as an accounting. That can take typically one of three flavors. There's disgorgement as a proxy for the plaintiff's injuries, where it's difficult for the plaintiff to articulate and prove up the damages it suffered. It's often the case that disgorgement of profits is used as some kind of rough measure of the harm that the plaintiff has suffered. A second mode is akin to unjust enrichment, and that's kind of an equitable doctrine that's premised more on the fairness or unfairness, as the case may be, of the defendant keeping any what are called ill-gotten gains from its bad acts. And the third kind of flavor is deterrence. It's less common, but still a viable path to disgorgement of profits. And that is often in tension with language elsewhere in the Act that says that remedies under the Lanham Act are meant to affect, to put the plaintiff in the place where it was prior to the infringement and not to punish the defendant. So there's a tension between deterrence and punishment. So for today's purposes, we're going to really talk about disgorgement of profits, but all three of the different types are governed by what we're going to talk about today. And disgorgement of profits is pretty straightforward in the Act. The plaintiff's obligation is to show the amount of the defendant's profits. Essentially, in a trial, you have someone identify the amount of revenue attributable to the sales of the accused products. And then from there, the burden typically shifts to the defendant to identify any costs or other deductions from the revenue to arrive at a profit figure. And that's often a battle of the experts. And then an aspect of damages that isn't expressly articulated in the Act, but is nonetheless a widely recognized component of the damages calculation is causation. And that's something we're going to talk about more towards the end of our discussion today, and that's how causation may interrupt the direct line from liability to damages or reduce the amount of damages when we're talking about disgorgement of profits. So disgorgement of profits in some jurisdictions required proof of willfulness on behalf of the defendant, right? That the defendant purposefully adopted the mark with the intent of confusing consumers. Now, there's a range of behavior that may be identified as willful, right? There's just selecting a mark with the knowledge that the plaintiff owns the mark, and there, on the other end of the spectrum, there's purposeful free riding. So there's a whole range of conduct captured within that one word, willfulness. So different circuits had different standards for whether willfulness was required as a precondition to disgorgement of profits. That split is what led the Supreme Court to taking the Romag case. And that's where we start to understand why Romag's important. And I think next, Sheryl's going to tell us about how the Romag case came to be, its facts, its holding, those sorts of things.
So the upshot is that Romag held that a plaintiff in a trademark case is not required to show that a defendant willfully infringed its trademark as a precondition of a profits award. Said more simply, a willfulness finding is not a prerequisite to profit disgorgement. However, the court did affirm in its decision that a defendant's state of mind does and should have a bearing on what relief a plaintiff may receive. So how did the court get there? Well, let's just back up for a minute and talk a little bit about the facts of the case. The case was brought by Romag Fasteners against Fossil, who I'm sure many of you are familiar with, make watches and other leather goods and things like that. And Romag makes fasteners for handbags and those types of products that Fossil sells. Fossil and Romag had entered into a contract where Romag would supply fasteners to Fossil for its products. But despite that agreement, after a period of time, Romag came to learn that Fossil's overseas manufacturer was instead using counterfeit Romag fasteners, and Fossil was doing very little to prevent it. So Romag sued Fossil and the case went to trial. At trial in front of a jury, the jury found that Fossil acted in, quote, callous disregard of Romag's rights, but did not find willfulness. Based on that ruling, or that finding, the district court refused to award Romag Fossil's profits because the governing Second Circuit precedent required first proof of willfulness. So the Second Circuit was in that group of circuits that Mark described earlier, whereby willfulness was a prerequisite. So based on that, because the jury did not find willfulness, the court would not award Romag Fossil's profits. So that's the context in which the case came to the court. And with respect to examining the issues, the decision is relatively short and really just focused around statutory interpretation. And the real key for the majority was the fact that the Lanham Act is careful and precise when it wants to specify intent and state of mind. And particularly, the court focused on the language of the Lanham Act that talked about, under Section 1117, what remedies are available, and the differences in the language that can be found there. So in Section 1117, it states that a violation under Section 1125A, which is the section that was at issue for Romag, which deals with false and misleading use of trademarks, is based on that violation, profit disgorgement is appropriate. Or a willful violation under Section 1125C, which covers dilution. So the court found it very telling that in that portion of the statute, those who drafted the Lanham Act took the pains to spell out that a willful violation under 1125C would lead to profit disgorgement, whereas just a violation under Section 1125A would also lead to profit disgorgement. So that was really the key and center of their opinion. Trying to get around that, Fossil attempted to rely on the statute's provision that any award of profits is still subject to, quote, the principles of equity. But the court really didn't find any help for Fossil there. The court held that that language does not imply in any way that any sort of intent or willfulness is a prerequisite to the profits award. But reviewing the case law that led up to the enactment of the Lanham Act and those cases since, the court did hold that a defendant's mental state is, quote, a highly important consideration in determining whether under those equitable principles an award of profits is appropriate. So essentially what the court did was come down on the side of those circuits that had held that willfulness is not a prerequisite, but it is a consideration in determining whether profits should be awarded. The other notable thing about the decision is that Justice Sotomayor concurred in the holding, but did not concur in the reasoning, because she took issue with the majority's suggestion that courts of equity were just as likely to award damages where there was innocent infringement as there was willful infringement. But the court didn't really grapple with this issue that, as Mark said earlier, there are degrees and there's a sliding scale of what infringement may look like, of those who have just knowledge of a registration all the way through intentionally intending to free ride off of the plaintiff's goodwill. And she did point out helpfully in her concurrence that the weight of the case law actually shows that profits are hardly awarded, if ever, in instances of quote unquote innocent infringement. So where Romag leaves us is not very different from where we were beforehand, except for if you're in circuits like the Second Circuit that previously had willfulness as a prerequisite. Willfulness still remains an important consideration in determining whether profits should be disgorged, but it is no longer a first hurdle that a plaintiff must get over to have access to that particular remedy. So I think, David, we're maybe going to dive in now to some of the implications of Romag.
We were going to talk now about the implications and the practical result. Thank you very much, both of you, for that background and for the summary of the case. As we move on to the next phase, I'd like to set the stage with a hypothetical. And so that we can think in somewhat concrete terms about what Romag means and maybe what it doesn't mean. So let's imagine that there is a supplement, vitamin supplement manufacturer that wants to come out with, or has come out with, a new product for bodybuilders or weightlifters, a supplement. And it picks as its name Prozam, Prozam. And before it picks that name and decides to go public with sales, it does a search, clearance search. And it finds an existing trademark for antidepressants called Prozac, which is manufactured by Eli Lilly and Company. And it makes a determination on the likelihood of confusion, decides that it does not think there is a likelihood of confusion between Prozam vitamin supplements and Prozac as a prescribed medication for depression and anxiety. Now, it makes that determination based on all of the factors that usually go into a likelihood of confusion analysis, including how likely it is that the products overlap in the marketplace, the similar or dissimilar channels of distribution, who are the relevant buyers, and so on and so forth. So after doing so, however, let's say it gets sued by Lilly for trademark infringement. If Lilly, of course, would have to prove that it has a registration, let's say, in Prozac, and it has to prove likelihood of confusion, and it has to prove damages if it wants any profits that were made by the vitamin manufacturer. So what we're going to look at, in addition to other things, is did Romag change the way that that case would get litigated today, from before Romag and after Romag? And I think as another matter, what kind of advice would you have given the plaintiff in this case in terms of clearance if you had been asked before it selected its mark? In terms of Romag, is it on riskier ground now in selecting Prozam as a mark than it maybe would have been prior to Romag? So with that, I think, Mark, you're going to talk about the implications of the case in the first instance. And why don't you go ahead and take it away?
Sure. So I think there are two ways to think about the impact of the case, the Romag case, on the hypothetical you put forward. One is the nature of the actual risk of losing a money judgment. And the other is the nature of the risk of engaging in a dispute, which itself has its own risks and costs. Those costs include time and legal fees, right? And the reason why I put them in two different categories is I think from, strictly looking at the risk of losing a money judgment, the analysis is essentially the same as it was previously. Perhaps if you were in the Second Circuit or one of those other circuits where willfulness was a prerequisite, you had a different approach that you could take. You could very early on try and address directly the willfulness question, get some good testimony on that issue, and move for summary judgment and avoid any risk of disgorgement. That's now out of the defense counsel bag of tricks. You don't get to do that in any jurisdiction. But the nature of the risk is really the same as it was in those jurisdictions that didn't have willfulness as a requirement. And generally, when you're giving advice on litigation risk as it relates to damages, you're going to the lowest common denominator, right? You're not going to necessarily give your advice assuming that you're only going to get sued in the most beneficial jurisdiction for the defendant. You're going to parse the different circuits and identify those with the lowest bar and premise your risk analysis on the low bar, which is those circuits that didn't require willfulness as a prerequisite. So strictly speaking, the analysis that you're going to make about your risk of losing money judgment in advance of suit when you don't know where you're going to get sued is about the same. I think, though, that Romag is going to affect the way plaintiffs perceive their cases and the way they pursue their cases. So that means that you have perhaps the same risk of an eventual money judgment, but you have an increased risk of plaintiffs bringing suit and becoming embroiled in a litigation with its, costs and the time that it takes to engage in, defense. So plaintiffs are going to be sold on the notion that the bar is lower. They're going to be more aggressive in that way. Lawyers doing what lawyers do, they're going to take the view as plaintiffs that the law has changed and the bar is lower. I don't necessarily think that is the case as a practical matter, but it's going to cause suits to become more common and to be more aggressively pursued. And the case that you describe in the hypothetical is the sort of case where disgorgement of profits is really what's at risk, right? Because it's going to be very difficult for Lilly to prove that it lost sales of its antidepressant as a consequence of Mega's sales of dietary supplement, right? It's very unlikely that they're going to be able to show that. But if the focus is entirely on defendant's conduct and its profits, right, there's potentially a means for a monetary award, which there might not otherwise be. So those are the sorts of cases where the client's risk of an eventual money judgment is likely the same, but the risk that the case may be brought is probably higher. And given the expense of litigation and the fact that it distracts from your business operations, you need to build in that additional risk factor into the advice that you give the business folks, right? Because previously you may have come to the conclusion that the risk is, let's say, in a scale of 1 to 10, a 5. But now the risk of the claim being brought is probably a 6 or a 7, if that makes sense.
Okay, so if it does make sense, I think, but in a way.
Can I just add one thing there too? I think
Sure.
just as a practical matter too, in the hypothetical that you spun out, the larger company, Lilly, was the plaintiff in that suit, where Mega was more of a startup, smaller company, and where there may be profit disgorgement available there, it's probably going to be a slightly smaller pool. So in what Mark is talking about around the idea that this litigation may be more attractive to plaintiffs, particularly clients who are larger clients who have larger volume sales, it's going to even look that much more attractive because they're going to perceive the bar as lower, and those clients who already had a bit of a target on their back because they have high revenue associated with the products at issue, it just got that much bigger because of this idea that it's going to be easier to get to those profits.
So then let's think about this from the clearance point of view. When you're counseling a client, I don't know if I mentioned in the hypothetical when I laid it out that the hypothetical name of the hypothetical plaintiff is Mega, the supplement maker. No, the plaintiff, I'm sorry, is Lilly. The defendant is
Right.
Mega in this hypothetical. So what do you tell Mega if before they move into the market and start to brand their new supplement as Prozac, and they say, well, Mark and Sheryl, what's the worst thing that could happen to us? Can't we just change our name if we're held liable for trademark infringement because a judge or a jury thinks there's a likelihood of confusion? And I would imagine you would say, well, that's not the worst thing that could happen to you. The worst thing that could happen to you is you would have to pay for the cost of litigation, change your name, and pay them money. If they sued you, let's say after a year, and let's say you had made, let's just throw out a number, right? Let's say you had made $5 million in gross profits. Business people are sitting across you at the table and they really like this name. Their marketing people have told them Prozam is fantastic. We've market tested it, pre-tested it. It conveys what we want to convey emotionally about our new branded product. And now it's your turn, right, to tell them, and they look at you as clients sometimes do, right? And they say, what's the worst thing that could happen? So I think that's the question that kind of Romag speaks to, right? And what you tell them now, I think is different, is my own sense, and it's from listening to both of you. I also think you guys think that it's different. So what would you tell them? Either one of you.
Sheryl, want to go first?
So I think setting aside the fact that part of that advice would be really keyed into the likelihood of confusion analysis, which isn't exactly the topic for today, but of course that's a key part of any of the analysis and walking into this. But assuming that we feel like there is a potential for a loss on likelihood of confusion and that we're going to be in the damages realm, I think that the advice is slightly different, but not substantially different from the prior advice we would have given to Romag, because I think, as Mark said earlier, when we look at this, we always look at the courts with the most liberal construction on damages. So not knowing where you might be sued, we were always looking to those circuits that Romag has embraced in terms of willfulness being a factor, but not a hurdle that they have to overcome. So I think that's a piece of it, is, particularly in speaking to any client about Romag, is this is always on the table. But now factoring in that additional risk around the fact that it may just be more likely that that suit is going to happen than it was before. And I think that's the key piece in making the business people understand and be able to evaluate that risk for themselves, because it may be that they love the name. And we'll talk a little bit later, I think, about what we want our business people to be saying around how important the name is, or whatever the trademark piece is. That's the center of this that we're analyzing. But I think, you know, the key really is there that they may just have a larger target on their back than they did before. And so any risk calculus needs to amp up the risk a bit. But in terms of the legal analysis being applied and what the courts are going to look to, the courts like the Fifth Circuit are still going to be implementing the same tests that they were previously around balancing various factors to determine whether profit disgorgement is available. But really, it's a threshold question of is the suit just going to be a little bit more likely than it was previously? Mark, do you want to add?
No, I agree with that completely. And I think one thing to keep in mind is that you can never, at least in my practice, is to never tell a client something's a sure thing, right? Because if you get in front of a fact finder, I don't care how good your case is, there's a 10% chance you're going to lose, right? Because fact finders can just see things differently, right? But different people with different point of view, different life experiences, they can just get it wrong. So I think with the increased risk of a suit and the increased risk of a suit focused on disgorgement of profits increases the overall risk, because if you have more cases that are focused on that and they can get to a fact finder, you may have more judgments against you, just as a matter of probability. So you have to keep that in mind, right? That a case that may have been resolved previously with the exchange of letters may start instead with the filing of a complaint. And if you, as a plaintiff, get past the motion to dismiss or summary judgment phase, who knows what can happen, right? It all comes down to what your evidence looks like. And that's, as Sheryl alluded to, something we'd like to talk about shortly, which is what are the sorts of things that businesses do that are either profoundly unhelpful or very helpful at trial on the issue of disgorgement. Because if you know that there's going to be a renewed focus on disgorgement of profits, and you know that you're an entity that is of some size and you have a lot of revenue, no matter what you sell, you need to be mindful of these issues, because we're talking about documentation surrounding your revenue for, it's documentation that doesn't yet exist. So you can, because you're aware of these issues, be complete in how you memorialize things so that in the event of litigation, you're in a better position than you otherwise would be. You're not explaining away documents, you have documents that show a full picture. So we'll talk about that in a few minutes.
Yeah, let me just push you both a little bit harder on this hypothetical.
Yes.
You've all been in these kinds of conversations with clients, and they listen to all of this, right? And they say, okay, let's say, I'm gonna set it up a little bit more. Let's say that in this case, Prozac versus Prozam, prescribed drug versus dietary supplement or bodybuilding supplement. Let's say you looked at all the facts, and before Romag, you concluded that the risk of liability at all under likelihood of confusion analysis is roughly 40%, less than 50%. But if you conclude that if you do lose on likelihood of confusion, it is more likely than not that the plaintiff would not have to pay damages, disgorgement damages, depending on the jurisdiction you're in. Let's assume you were in a jurisdiction that required willfulness, and that you knew that was going to be the jurisdiction that was sued in, or you could reasonably predict that. I know that was something you mentioned earlier, which was
right.
Interesting, that maybe sometimes you just can't, especially at the clearance stage, reasonably predict what circuit you would have been sued in anyway. But let's say you could, and you say, well, was it willful? Let's ask that sort of basic question. Was it quote unquote willful for Mega to pick Prozam as a name when it knew about Prozac, because the registration was publicly available and it found it? But it did an analysis, and maybe partly with you, and decided that it was less than 50% likely that there would be a likelihood of confusion. And so it thought to itself, it could proceed in quote good faith, because it was less likely than not that they would be confusing consumers. So, let's say it was 40% and it was less likely than not, and now we have Romag. And you're sitting there at the table with a client. How much has it gone up? Is it possible, I know it's putting you guys both on the spot, but is it possible, even in a rough sense, to kind of quantify? Like, has the risk on a scale of 1 to 10 of disgorgement damages gone from a 4 to a 6, if there's liability? Is that the kind of margin that we might be talking about?
I think it's marginal, right? I don't think it's material, but what it does is it puts a renewed focus on the clearance process, on the facts that are going to be in play on disgorgement. So clients and their counselors need to pay particular attention to what they know and the reasoning behind their marketing choices and their branding choices. And so if you know that you only are, you're at one end of the willfulness spectrum, lock down those facts early, right? That's fine. I mean, there's lots of case law to the effect that mere knowledge of a competitor's mark, and query whether Mega and Lilly are competitors in this context, but we'll put that aside, assume they are, that mere knowledge of a competitor's mark is not willful infringement. Now, there's some law that goes the other way, but if you're in the good faith end of the spectrum, there's a lot of solace to be found in Sotomayor's concurrence, right? Because she calls out the fact that there's a spectrum of behavior that can qualify as willful. So knowing that that's going to be in play, what you want to do is really assess at the front end, where are we on that spectrum, right? You never want a client on the far end of the spectrum, right? Purposefully choosing a free ride on someone else's mark. That's a terrible idea. Putting aside that it's just not lawful, it's just a bad marketing idea, right? So it just puts renewed emphasis on that. And if you focus on it in the clearance process and make those judgments early, you're going to be able to mitigate what I think is a slightly increased or marginal risk of an eventual award. But that is a component of that is the assumption that you're always advising in a marketplace where you don't know where you're going to get sued. So you're looking to the lowest common denominator.
Yeah.
Now, let me just add one thing. One thing that defense counsel have now lost, in addition to potentially being able to move early on summary judgment on a willfulness finding and kind of take disgorgement off the table, you've lost the ability to argue the fact of the split, right? You always had the ability to argue that, well, look, we may be in the Fifth Circuit. The Fifth Circuit applies willfulness as merely a factor, but the Second Circuit and several other circuits say it's required. And you can argue they're right and the Fifth Circuit's wrong, right? So you don't have the option of making those arguments anymore. But those are never leading arguments to begin with, because the circuit you're in controls, right? So those are arguments not directed at the federal district court judge or the jury in their instructions. Those are arguments that are focused at the Court of Appeals eventually. And by the time you get to the Court of Appeals, if you're appealing that issue, you've lost a disgorgement of profits judgment, which is a bad thing. So it's really not much, if anything, by way of difference.
Okay, before we move on to, I think, the next sub-segment on how to advise clients in light of this, I did think of a question while we were going through the discussion of the hypothetical. Romag does not pertain to a dilution suit, right? It's a different section of the Lanham Act. And it occurred to me that intentionally or unintentionally, I had chosen a hypothetical that involves a famous mark, or allegedly famous, potentially famous mark, that Prozac is known to substantial portion of the American consuming public in general. It might be, and assuming it is, and assuming Lilly has a famous mark and at least an arguable dilution claim, on the dilution claim, would it still have to prove willfulness to get disgorgement damages?
I think the language is, that particular statutory language is the distinction on which the Supreme Court finds that willfulness is not a prerequisite under 1125A. So the Lanham Act is explicit with respect to dilution that willfulness is required before disgorgement is available. And given that that is the express reasoning behind the decision in Romag, I don't imagine that issue being disturbed. So I think people can feel pretty confident that willfulness remains a requirement to profit disgorgement under a dilution theory.
That's what I was thinking, too. I wanted to tease that out. That could make
it was nice to get one right.
We're back in law school. Sorry, guys.
Right.
That could make a difference in the real world, right? Wouldn't you think that Lilly's dilution claim on the merits might be a tad bit stronger than its confusion claim? Prozam and Prozac, maybe there isn't a likelihood of confusion that people think they come from the same company. But Lilly, if you were the lawyer for Lilly, at least you would make an argument. You'd probably raise it in your complaint that it's a famous mark, that it's been diluted through blurring with Prozam. And if that mark becomes more well-known, Prozam, it will arguably dilute the commercial magnetism of the Prozac mark in a way that's perhaps measurable. But in order to win on that claim, you have to prove willfulness. and you have to prove willfulness under the statute and in every jurisdiction. And so that risk remains sort of buffered, I guess, by that. Whereas the confusion risk doesn't anymore, which is interesting, right? It's kind of, there's now a real gap between, I think a clear gap between getting disgorgement damages in a confusion case versus a dilution case. All right, well, I want to save time for Q&A with the audience, and we are going to try to do that and give them 15 minutes. We're already at 10:42, but can we spend 4 minutes or 5 minutes maybe at the most on the next section, which is, so how does this case translate into advising clients? And which one of you wanted to take the lead on that?
Well, I was hoping to talk about how clients and their counselors can interrupt a disgorgement claim by focusing early on causation. And I think Sheryl was going to talk about some of the evidentiary issues that goes along with that, including survey work, if that makes sense.
Yeah.
So as I said at the outset, one of the things that's important to keep in mind is that although it's not in the act itself, causation is a critical component of proving and disproving an entitlement to monetary relief under the Lanham Act. And the reason why is that, when you're think about it in the context of unjust enrichment, even within that phrase, there's a requirement that the enrichment be unjust. So where the sales success of a product is attributable to the name alone, the accused name, there's a direct connection between the sales of those products and the profits made, and they may all be subject to disgorgement. If, however, there are a variety of reasons why consumers purchase the good, so that the profits are attributable to multiple different reasons in the marketplace, there's no direct line. So your profits attributable to the infringement are either zero or some percentage less than 100%, right? So it's simple stuff. If you ask a marketer or a salesperson why consumers buy their products, they'll give you a whole host of reasons. Brand name is one among them. You have things like value, quality, design, warranty, right? There's a whole host of things that cause consumers to buy stuff. Brand is but one among them. So from the plaintiff's point of view, the accused mark is the only reason that the product sold, and they ought to get all of the profits that go along with those sales. From the defendant's point of view, well, the accused mark is maybe part of one of the reasons why consumers bought the goods, but it's not every reason. So that's where you find the causal question. And knowing that that causal question is important, you need to think about what this is going to look like at trial, what your documents are going to look like, and what your witnesses are going to say. So marketing folks, being marketing folks, when they engage in a rebranding project, they're going to do some ROI after the fact and attribute increased sales to their work. They're going to justify their existence. They're going to say, hey, we did a heck of a job. We sold a bunch of products as a consequence of our rebranding efforts. That's a document that's very plaintiff friendly, right? There's a document that says, look, the company's saying that the use of the mark that we accuse as infringing is the reason why they sold all these goods. Give us all the profits. That's a natural impulse for marketers and business people who are engaged in rebranding products or just branding new products. You need to figure out a way to engage with your business teams and explain that it's useful for their job to understand the impacts of what they do, but the documents they create fit in a larger context of a potential litigation. So when you're describing the effects that you attribute to this rebranding project, look at the whole picture. Don't exclusively rely on the brand, unless it's true that it's only the brand that is causing the product to sell. And I've been at this for 20 years, and as much as I love marketers, because they're the folks that we trademark lawyers intersect with the most, it's not the case, I've never seen it, that the brand is the only thing that causes people to buy a product. So we need to figure out a way to give in-house counsel the tools to communicate with their clients, the business people, so that they understand that the way that they conduct their business and they measure their success is just playing into the plaintiff's hands. So think more broadly about the reasons why consumers buy products so that you can more accurately and fairly address the question of what profits are attributable to the alleged infringing acts. So that's how you deal with your internal documents and how your marketing people think about their rebranding efforts. And Sheryl was going to talk about how you do that perhaps after the fact, externally, by doing some survey work in the litigation context.
Yeah, so as Mark said, ideally you can get ahead of some of this before litigation even comes, and trying to work with your marketing people on how they're crafting their messages on documents that may come out in litigation. But the one thing you do have complete control over is, once litigation has ensued, survey experts that you're retaining and the types of surveys that they're doing. So one tool that we've used, and I think is going to become increasingly popular, is to do a purchaser motivation survey. So we're all probably very familiar with the typical types of likelihood of confusion surveys and secondary meaning surveys that are often conducted in trademark litigations. But I think there is a lesser focus, or there has been so far, on purchaser motivation surveys, which really are designed to look at, why are people buying the product? Is it because of the trademark name, or is it because of the features, or the price, or the quality, or some other aspect of this product that has nothing to do with the name whatsoever? And those types of surveys can be really effective at getting at this issue, because even despite what the internal documents might say and the perception the company may have about why customers are purchasing its product, unless you actually go ask the customers, it's hard to know why they're buying it. And you can do that pretty easily and effectively. Unfortunately, not too cheaply, because these surveys are not completely inexpensive, but you can do it in the course of litigation and actually go out and survey consumers, who sometimes we've done them in the context of asking actual purchasers why they bought the product via email list or things like that, or doing a more theoretical survey study of potential consumers in the marketplace and posing the survey question to them of, you've been shown this product, why are you going to buy it? And using the right controls, you could control for the fact of, is it the name, or is it something else that's driving people to buy these products? And there are a number of different ways that these can be conducted to best fit the situation, but it is a very valuable tool in your arsenal to defeat these profit disgorgement claims.
Thank you. I think with the time, we have about 10 minutes left. If we could see if people have submitted questions, we can go to those from the audience, and I can read them to you on the panel. Kelsey, can you show me that? I need to oh, I think I have 3. All right. All right, so let me ask this question. I think one of the more significant impacts of Romag is with respect to waiver of privilege. In your hypothetical, the supplement manufacturer may feel compelled to waive privilege and share the pre-launch analysis to avoid a viable profits claim. What are the panelists' thoughts on that?
We could spend another hour on clearance and waiver of privilege. So a problem that we encounter a lot with new clients is that they're often under the misimpression that they have a clearance opinion. when they don't. They have an opinion that is really cast as a balancing of risks that may or may not be useful, right? So if you're looking to waive privilege, you have to be, thoughtful about giving counsel very specific instructions that we want a clearance opinion. We don't want, an analysis of pros and cons and percentages, because more often than not, lawyers being who they are going to spell out the worst case scenario, and that's not helpful. And you also have to think through, which counsel's giving that opinion. Is it the same counsel who's going to be your litigation counsel? So there's a whole host of issues surrounding how you give clearance opinions, what's in them, who does them, whether to disclose, how far, depending on what jurisdiction you're in, the waiver may reach. So that's a great question to ask. And I think the short answer is that waiver may be more important, and you should focus on it earlier. But I just can't give you a more crisp answer than that, unfortunately.
All right, let me go on to the next question. There are a few more. Does it make sense to conduct the purchaser motivation surveys well before litigation actually ensues? Are there ways to mitigate risks that in advance by doing a survey?
Sure. So yes, ideally, the earlier you can do your survey work, the better. It gives you one of the clearest insights into exactly what the key evidence in the case is going to look like. Surveys are highly valued in trademark litigations. And so as a general principle, whether we're talking about purchaser motivation surveys, likelihood of confusion, secondary meeting, my view is do them early. The earlier the better, because you just get a better sense of what your case looks like. And that certainly is equally true for the purchaser motivation surveys as well. And I think part of the question was around, is there a concern about mitigating risk of the results may not come out the way that you want them to? And there are certainly ways to do that. Certainly when it comes to litigation, it's your testifying expert and what they've relied on and considered that is what gets disclosed. So you can certainly run surveys with a non-testifying expert that would be subject to work product protections, review those results, and determine whether you want to go forward with the survey at all, if you think it's something that's going to be useful. So without disclosing those to anyone who's going to testify in litigation, you can create work product that allows you to effectively assess your case and what the results may look like without automatically creating evidence that's going to have to be disclosed. If it's under a situation where you reasonably believe there's a threat of suit, so it meets the work product protection, along with, of course, the attorney-client privilege protections, you can craft those surveys and run them so that they are completely protected. And again, this is another topic we could spend an hour on. I'd love to talk about surveys. But
David, real quick, let me just add something to that. If you do the survey yourself and you do it early enough, you do it pre-launch, at the point where marketing has some leading contenders for a brand, but they haven't landed on it. If a particular brand comes up really bad in the internal results, you can change course, right? You can pick a different brand. So there are advantages to doing it early beyond mitigating risk of using that mark. You can just choose to go in another direction, which itself can sometimes be helpful.
There's two follow-up questions, I think, related to this. One is, based on your own experience as lawyers in this area, what's a rough price range for a purchaser motivation survey? And maybe that depends on whether you're doing it pre-litigation with, just to kind of see what it is, or whether you're doing it in litigation. Is that something either of you off the top of mind are comfortable giving a range on?
Yeah, I think when you assess the cost, there's a couple different components that go into it, just so everyone's on the same page. So there's the actual cost of designing the survey and working with a survey expert who can create the survey design. There's a essentially fixed cost of putting a survey in the field that is unavoidable because you need to use certain survey panels to get to people who can answer the questions for you. So, I mean, in my experience, the purchaser motivation ones that we've done have run anywhere from, you know, $40,000-ish on the cheaper end to they can go upwards of, you know, $60,000, $70,000, not including report costs. So it just depends how complicated it is. And I will say some of these can be complicated because they can be conjoint analyses, which are some of the more complex type of surveys that are being done. So they can run more to that heading towards six-figure range for these types of surveys. Mark, is that consistent with what you think?
Yeah. Under the heading of those are litigation-related costs.
Absolutely, litigation
right?
surveys, yeah.
So companies can do them either internally or through a vendor themselves for a lot less. But the surveys aren't going to be built to withstand scrutiny in litigation. So you can save some money and get some directional results and kind of do it in-house on your own. But don't think that you're going to be able to turn around and use that same work product in a litigation. It may be helpful, but it's not necessarily going to lead to a testifying expert being able to adopt it as their own and present it to the fact finder.
Yeah. Yeah, there are quick and dirty ways to do it, but understanding they are quick and dirty and they're not going to be polished litigation ready surveys.
And sometimes that's all you need.
Yeah.
I think this is the final question. I'll just review what the question says. To what extent does this planning to avoid willfulness lay the groundwork for a finding of willfulness later?
I like that.
So I think the key is that it has to be truthful. So that's the thing at the end of the day. What Mark is talking about is the effect that there sometimes is a tendency to tout portions of the name that may not actually underlie what the data reflects. And so if the data is more accurately reflecting the fact that other factors are leading to people to buy this product, you want to be accurately reporting that. I think this is more, it's not by any means saying to create evidence that would not be in line with what is actually happening in the marketplace, but rather to accurately reflect the marketplace in instances where the name is not the crucial factor in the decision-making for consumers.
Of course, just said another way, if presented with a document that looks like the name is the only reason why a product sold, and you ask the marketer, is that the only reason why the product was successful? Did consumers also care about quality? Yes. Did consumers also care about warranty? Yes. Did they care about features? Yes. Did they care about value? Yes. So is it fair to say that it's not the name alone that is the attribute that has caused the product to sell? Yes. That's pretty much always the case. So you just want your documents to reflect the truth and reality, and the nature of marketing is such that you have documents that are unnecessarily focused when they don't need to be, and they're necessarily unhelpful. That's all.
Great. Well, I think we're, Kelsey, we're at our limit. And I thank both of you very much for the excellent discussion we had, and thank the audience for tuning in. I will mention our next podcast is 2 weeks from today at the same time with Dr. Sarah Kagan from Banner and Witkoff in Washington, D.C. And the topic is patenting around issues around vaccines and therapeutics for COVID-19. We hope you can dial in for that, and we look forward to seeing you again. Any final word, Kelsey?
I think we're good. Thanks everyone for joining and for your discussion. This will be a recorded session available online, which we'll send a link out to in the next day or so.
Thank you, everyone. Take care.
Thank you.